Good morning, this is your Kelso Report for Friday, August 26th, and I'm your host, Clark Kelso. We have today just a number of one-liners. First, environmental law case, Barnes versus the United States Department of Transportation. A two-judge majority of a Ninth Circuit panel held that the Federal Aviation Administration improperly approved the construction of a new runway at Hillsboro Airport in Oregon, pursuant to a finding of no significant impact, thereby relieving the agency of preparing an environmental impact statement. The court concluded that the FAA had failed to consider the environmental impacts of any increased demand at the airport resulting from the addition of a new runway. The dissent argued that a number of Ninth Circuit cases had established a general rule, which should have applied to the facts here, that expansion of an existing airport to meet anticipated growth does not have any growth-inducing effects that require environmental analysis. To the contrary, expansion to meet anticipated growth is designed to reduce the negative environmental consequences that occur when an airport is required to operate above its approved annual service volume. Because when demand reaches capacity, airport delays increase dramatically, which means that airplanes will have to idle longer before taking off and circle longer before landing, creating increased air emissions. Even though the dissent's analysis appears to be somewhat more consistent with prior Ninth Circuit case law than the majority's analysis, I think there is a great deal of common sense in the majority's conclusion that construction of a new airport runway must have some environmental consequences worthy of study in an environmental impact statement. It's a pretty major piece of construction to receive a finding of no significant impact. Next, an interesting evidence case in People v. J.A. The 2nd District affirmed the juvenile court's admission into evidence of hearsay statements of a 3-year-old victim of a lewd act, which established the corpus delicti. The 3-year-old's testimony was the only evidence of the crime other than the defendant's own extrajudicial statements. Under Evidence Code Section 1228, if a victim under the age of 12 describes circumstances of sexual abuse, and there are no significant inconsistencies between the victim's statement and a subsequent confession by the defendant, then, if the child is unavailable to testify, the child's hearsay statement is admissible, quote, solely for the purpose of determining the admissibility of the confession of the defendant, close quote. In yesterday's case, the defendant, under persistent questioning, ultimately admitted to touching the 3-year-old in a lewd manner. Because the victim's statement was consistent and satisfied the other elements of Section 1228, the victim's statement was admitted, as was the confession, and the defendant was ordered to be placed home on probation and participate in a sexual offender treatment program. Next, a tax case in City of Palmdale versus Palmdale Water District. The 2nd District struck down a new water rate structure adopted by the Palmdale Water District, which charged irrigation water users, such as the city, at higher rates than other users. According to the court, these disproportionate rate charges violated Proposition 218, which, among other things, provides that no fee or charge imposed upon any person or parcel as an incident of property ownership shall exceed the proportional cost of the service attributable to the parcel. The Water District could not establish that its elevated rate charged irrigation water users reflected costs of water service, and as a result, the court struck down the rate structure. Next, a case of mootness in Coalition for a Sustainable Future in Yucaipa versus City of Yucaipa. The 4th District held that the plaintiff's appeal from a denial of its writ of mandate to stop a city from approving construction of a Target store on city-owned property was moot when Target abandoned the project. The city rescinded the resolutions approving the project, a general plan amendment necessary to the project, and the certification of the environmental impact report for the project. Given all of those rescissions, the 4th District held the case was moot. Its final disposition was to reverse the denial of the writ of mandate, which restored jurisdiction to the Superior Court so that the Superior Court could then dismiss the action on mootness grounds. Finally, a qualified immunity case. In Chisholm v. Washington State, the Ninth Circuit held that a police officer who submitted an affidavit for a search warrant to seize and search a computer for child pornography was not entitled to qualified immunity because the evidence showed the officer had intentionally or recklessly included false statements in the affidavit and deliberately omitted information that would have given other information in the affidavit a more innocent interpretation. And that's it for today's Kelso Report. Have a great day in the law.